If you live, drive, or rent a home in Florida right now, this video could change everything for you. Florida has become ground zero for the most aggressive immigration enforcement push this country has seen in decades. And it is not just affecting undocumented people. It is hitting families, landlords, and drivers who never thought they had anything to worry about. The laws have changed. The partnerships between local police and federal immigration agents are real, and the consequences are serious. Before you sign a lease, get behind the wheel, or open your front door to anyone, watch this. Number 1. Florida's SB 4C and the state's official role in immigration enforcement. Most people think immigration is a federal issue. You call ICE, ICE handles it. Local police stay out of it. That was largely true for years. Florida blew that idea up completely. In 2023, Florida passed Senate Bill 4C, which Governor DeSantis signed into law, and the effects of that law are now fully in motion heading into 2026. Under SB 4C, Florida law enforcement agencies, including your local sheriff's office and city police, are required to cooperate with U.S. Immigration and Customs Enforcement. This is not optional for them. It is a legal mandate. Any local government that tries to create sanctuary city protections, meaning policies that limit cooperation with federal immigration agents, can lose state funding. Florida Statute 908.104 makes this crystal clear. Local jurisdictions cannot adopt any rule, policy, or practice that limits enforcement of federal immigration law. What this means practically is that if you are stopped for a traffic violation in Miami, Tampa, Orlando, or any other Florida city, the officer has both the legal authority and in many cases the obligation to check your immigration status. The days of Florida cities quietly ignoring federal detainer requests are over. Sheriffs in counties like Hillsborough, Orange, and Broward, which previously had more lenient policies, are now operating under this mandate. The 287G program, a federal program that allows local law enforcement to be trained and authorized to perform immigration enforcement functions, has expanded significantly in Florida. As of 2025 and into 2026, dozens of Florida sheriff's offices operate under 287G agreements. That means the deputy who pulls you over for a broken taillight may have full federal authority to process your immigration status on the spot. If you are undocumented or have an unresolved immigration issue, understanding that Florida law enforcement is now functionally an extension of federal immigration enforcement is the single most important fact you need to hold on to. Number 2, who is actually being prioritized for deportation? The real targeting list. Not everyone faces the same level of risk, and understanding the priority tiers matters enormously. Federal immigration enforcement under current policy operates on a priority system, and Florida's cooperation amplifies how quickly people in certain categories get flagged. Priority 1 targets are people with criminal convictions, especially for violent crimes, drug trafficking, DUIs, domestic violence, and weapons offenses. If you have any of these convictions on your record in Florida and you are not a U.S. citizen, you are at the top of the list. Florida's court system and law enforcement databases are now directly linked to federal immigration databases, so a conviction does not just stay in the state system, it flags your immigration file. Priority 2 includes people who have been previously deported and re-entered the country. Re-entering after deportation is a federal felony under 8 U.S.C. Section 1326, and Florida authorities have specific instructions to flag these individuals immediately upon any law enforcement contact. Priority 3, and this is where many people are surprised, includes people who have simply been in the country without legal status, even with no criminal history. Under the current enforcement posture, anyone encountered by law enforcement who cannot demonstrate legal presence is subject to detention and removal proceedings. The old informal grace period for people with clean records and community ties has narrowed significantly. People with pending immigration court cases, expired visas, or final orders of removal that were never executed are also actively being targeted. Florida's courts and ICE offices have been given resources specifically to close out these old, unresolved cases. If you received a final order of removal years ago and nothing happened, 2026 is the year that may change. Number 3, Florida's driving laws and immigration enforcement. What happens at a traffic stop? This is where immigration enforcement and everyday life collide most often for Florida residents. A routine traffic stop can turn into an immigration detention. Here is exactly how that happens and what Florida law says about it. Florida does not issue standard driver's licenses to undocumented immigrants. Unlike states such as California, New York, or Illinois, Florida has no legislation allowing undocumented residents to obtain a regular driver's license or a driving privilege card. This means that if you are undocumented and driving in Florida, you are almost certainly driving without a valid license, which is a criminal offense under Florida Statute 322.03, not just a civil infraction. Driving without a license in Florida is a second-degree misdemeanor for a first offense, punishable by up to 60 days in jail and a $500 fine. A second offense escalates to a first-degree misdemeanor. The moment you are charged with a criminal offense in Florida, your fingerprints are taken and entered into state and federal databases. That biometric data goes directly into systems that ICE has access to. Florida Statute 316.615 also requires that every driver be able to produce a valid license upon request by a law enforcement officer. Failure to produce one gives an officer legal grounds to extend the stop, run further checks, and in counties operating under 287G, to initiate immigration screening. Here is something critical that many people do not realize. Even a minor traffic stop in a 287G county can result in an immigration hold being placed on you before you ever see a judge. You can be held in county jail on an ICE detainer while your minor traffic charge is processed. The detainer essentially asks the jail to hold you for up to 48 hours beyond when you would otherwise be released so that ICE can come pick you up. If you are driving in Florida without legal status, the risk is not just a ticket. It is a direct pipeline into immigration detention. Number 4, Florida landlords and the new legal obligations they face. This section is critical for landlords, property managers, and anyone who rents out property in Florida. The 2023 SB 1718 law, one of the most far-reaching immigration-related laws Florida has ever passed, placed brand new obligations directly on employers, and it has implications that extend into the landlord-tenant relationship in ways that are still unfolding legally. While SB 1718 primarily targeted employers with 25 or more employees, requiring them to use the federal E-Verify system to confirm work authorization, the broader legislative environment it created sends a clear signal. Florida is using every available lever to enforce immigration law at the state level. For landlords specifically, there is currently no Florida statute that requires you to verify the immigration status of your tenants. Under the Federal Fair Housing Act and Florida's Fair Housing Act, Florida Statute 760.20 through 760.37, landlords are prohibited from discriminating in the rental of housing based on national origin. Demanding proof of immigration status from some applicants but not others can expose a landlord to a federal fair housing complaint. However, landlords should understand that harboring undocumented immigrants while knowingly participating in their concealment from federal authorities is a separate federal issue under 8 U.S.C. Section 1324. The line between normal rental activity and federal liability is renting a unit to someone, which is lawful, versus actively concealing someone from immigration authorities, which is not. What does this mean for you as a Florida landlord? You are not required to be an immigration officer. You cannot refuse to rent to someone solely because of their national origin or perceived immigration status. But if federal agents come to your property with a valid warrant, you are legally obligated to comply. Florida landlords need to understand the difference between a warrant signed by a federal judge, which you must comply with, and an administrative ICE warrant, which is an internal document that does not carry the same legal force and does not give agents the right to enter your property without your consent. Know your rights and know your obligations. They are not the same thing. Number 5. Tenant rights in Florida when ICE comes to your door. This applies to every renter in Florida, regardless of status. Your rights as a tenant do not disappear because someone knocks on your door with a badge. Under the Fourth Amendment to the U.S. Constitution, every person on U.S. soil, citizen, legal resident, or undocumented, has the right to be free from unreasonable searches and seizures. This right applies inside your rented home. ICE cannot simply walk into your apartment or house without either your consent or a valid judicial warrant. An administrative warrant, sometimes called a Form I-200 or I-205, is issued by an immigration officer, not a judge. It does not authorize entry into your home. A judicial warrant signed by a federal judge does. The difference is enormous, and you have the right to ask, through a closed door, whether the warrant is signed by a judge. You are not required to open the door to find out. Florida landlords who have received notice that ICE will conduct operations at their properties have faced questions about whether they have a legal duty to notify tenants. There is no Florida statute requiring landlords to notify tenants of planned ICE operations. However, landlords also cannot actively assist in tricking tenants into opening doors or facilitate deceptive entry tactics. The Florida Residential Landlord and Tenant Act, Florida Statute 83.53, requires landlords to provide reasonable notice before entering a tenant's unit, typically 12 hours for non-emergency situations. This principle of tenant privacy in their home is embedded in Florida law. If you are a Florida tenant and immigration agents come to your door, you have the right to remain silent, the right to refuse entry without a judicial warrant, and the right to speak with an attorney before making any statements. These are not loopholes. They are constitutional protections that apply to you. Number 6, Florida's detention centers and what the processing system looks like. Once someone is detained by ICE in Florida, where do they go? Florida has one of the largest immigration detention systems in the entire country, and understanding the infrastructure helps you understand how serious and how fast this process moves. The Chrome North Service Processing Center in Miami-Dade County is one of the largest ICE detention facilities in the U.S. It is a federal facility operated directly by ICE and has a long history of holding detainees from South Florida and across the state. Chrome has faced repeated scrutiny from human rights organizations, but it remains fully operational and a primary processing point for Florida detainees. Glades County Detention Center and Broward Transitional Center are contract facilities, meaning private companies operate them on behalf of ICE. Florida also sends detainees to facilities in nearby states when Florida's detention capacity is full, which happens regularly during enforcement surges. Once detained, a person goes through a process that begins with a custody determination. An immigration officer decides whether to release the person on bond, on supervised release, or hold them without bond. People with criminal records, prior deportations, or flight risk designations are typically held without bond. Bond hearings take place before an immigration judge, and in Florida, the immigration courts in Miami and Orlando handle a massive caseload. As of 2025, immigration court backlogs in Florida meant wait times of months to years for a hearing. But under the current enforcement posture, detained individuals move through the system faster than non-detained cases. Once a removal order is issued by an immigration judge, the person is placed on a flight to their country of origin. Charter flights operate out of several Florida airports, including in Miami. The process from detention to deportation can happen in weeks if no appeals are filed. Number 7, mixing immigration status with Florida's criminal justice system. The intersection of Florida's criminal courts and immigration enforcement is where many people's situations become complicated very quickly. Even minor crimes in Florida carry immigration consequences that most people do not anticipate. Under federal immigration law, a crime involving moral turpitude or an aggravated felony can trigger mandatory deportation proceedings, regardless of how long someone has lived in the U.S. or how strong their ties to the community are. The definitions of these categories under the Immigration and Nationality Act are broader than most people expect. In Florida, a DUI conviction is treated seriously. Under Florida Statute 316.193, even a first-time DUI can result in significant penalties. From an immigration standpoint, multiple DUI convictions or a DUI that caused injury can be characterized as a crime involving moral turpitude, making a legal permanent resident subject to deportation. A single felony DUI in Florida is almost certainly an immigration disqualifying offense. Domestic violence offenses under Florida Statute 741.28 are especially dangerous from an immigration perspective. Under the Federal Violence Against Women Act reauthorizations and the Immigration and Nationality Act, a conviction for a domestic violence offense is explicitly listed as a deportable offense. This applies to green card holders who have lived here for decades. Drug offenses, even simple possession of marijuana under Florida law, carry federal immigration consequences that Florida's decriminalization trend does not erase. Federal immigration law does not follow state drug policy. If you are convicted of a drug offense in a Florida court, even if Florida subsequently changes or relaxes its drug laws, the federal immigration record of that conviction remains. If you are not a U.S. citizen and you are facing any criminal charge in Florida, you need an attorney who understands both criminal defense and immigration law. A plea deal that looks good from a purely criminal law standpoint can be catastrophic from an immigration standpoint. Number 8, Florida's employer verification law and how it affects undocumented workers. SB 1718, which took effect on July 1, 2023, fundamentally changed the employment situation for undocumented workers in Florida. And the ripple effects of that law are showing up in people's housing situations, their ability to pay rent, and their overall stability. The law requires all private employers with 25 or more employees to use the federal E-Verify system to confirm that new hires are authorized to work in the United States. Employers who fail to comply face fines and the loss of state licenses. For undocumented workers, this effectively closed off a large segment of formal employment in Florida that had previously been accessible. When undocumented workers lose income, they lose the ability to pay rent. When they cannot pay rent, Florida's eviction process under Florida Statute 83.56 is fast and unforgiving. Florida is not a state with extended eviction timelines. A landlord can serve a 3-day notice to pay or quit for non-payment of rent. And if the tenant does not pay or vacate within 3 days, the landlord can file for eviction immediately. Florida's eviction courts move quickly, often resolving cases within 2 to 4 weeks of filing. This intersection matters because an economic crackdown through employment verification is directly connected to housing instability, which is directly connected to people seeking informal living arrangements, which is directly connected to situations that can draw law enforcement attention. For undocumented workers in Florida, SB 1718 did not just affect their job. It set off a chain reaction that touched every part of their daily life, including where and how safely they can live. Number 9, legal resources, sanctuary policies, and what protection actually exists in Florida. Given everything covered so far, the obvious question is, what protection, if any, actually exists for people in Florida facing immigration enforcement? The honest answer is that formal sanctuary protections at the local level in Florida were effectively eliminated by SB 4C. Cities like Miami, which once had policies limiting voluntary cooperation with ICE, have been brought into compliance with state law. Florida Statute 908.104 prohibits local sanctuary policies, and the state attorney general has enforcement authority over local governments that try to maintain them. That said, legal organizations and nonprofits continue to operate in Florida and provide real, meaningful help. The Florida Immigrant Coalition is one of the largest immigrant rights organizations in the state and provides legal referrals, know your rights training, and emergency response coordination. Legal aid organizations in Miami-Dade, Broward, Palm Beach, Hillsborough, and Orange counties provide free or low-cost immigration legal services. Florida law does protect crime victims and witnesses who are undocumented through specific immigration relief categories. The U visa is available under federal law for undocumented individuals who have been victims of certain crimes and cooperate with law enforcement. The T visa is available for trafficking victims. These protections exist independently of Florida's enforcement environment and are administered at the federal level. Florida Statute 90.503 protects the confidentiality of communications with attorneys, and Florida's professional responsibility rules prohibit attorneys from disclosing client information. If you consult with an immigration attorney in Florida, those communications are protected. Churches and religious institutions have also historically provided sanctuary, not as a legal matter under Florida law, but as a practical and moral one. ICE has had a long-standing sensitive locations policy discouraging enforcement actions at churches, schools, and hospitals, though the current administration has moved to narrow or eliminate that policy. The legal status of enforcement at sensitive locations is evolving rapidly in 2026. Number 10, practical steps Florida residents, tenants, and drivers should take right now. This final section is about action. Understanding the law matters, but what you do with that understanding is what protects you and your family. If you are an undocumented Florida resident or have family members who are, start by building a safety plan. This means identifying an immigration attorney before you need one in an emergency. The Florida Bar Lawyer Referral Service at 1-800-342-8011 can connect you with attorneys who handle immigration cases. Having an attorney's phone number saved means that if you are detained, you or a family member can make contact immediately. Know the difference between a judicial warrant and an administrative warrant, and keep that knowledge accessible. Write it on a piece of paper and put it in your door. You have the right to ask through a closed door whether a warrant is signed by a judge. You have the right to not open the door if it is not. If you drive in Florida, follow traffic laws meticulously. No rolling stops, no expired tags, no broken lights, no speeding. These are the most common pretexts for traffic stops. Florida Statute 316.610 allows officers to stop any vehicle that appears to have a mechanical defect. A broken taillight is enough. Eliminate the reasons to be stopped. If you are a Florida landlord, update your understanding of your legal obligations. You cannot discriminate based on national origin. You are not required to verify immigration status. You are required to comply with valid judicial warrants, and you are not required to assist with administrative ones. A real estate attorney can help you understand where your liability begins and ends. If you are a Florida tenant, document your residency. Keep copies of your lease, your rent payments, your utility bills, and any correspondence with your landlord. This documentation matters both in immigration proceedings and in Florida housing court. And if you have any unresolved immigration matter, a pending application, an old removal order, an expired visa, the worst thing you can do in 2026's enforcement environment is wait and hope it resolves itself. An immigration attorney may be able to reopen a case, file a motion to reopen removal proceedings, or identify a relief pathway that was not available when your case was originally decided. Florida has hundreds of qualified immigration attorneys. Use one. If this video gave you information you did not have before, share it right now. Send it to someone in your family, your apartment building, your workplace, anyone who needs to understand what is happening in Florida in 2026. The people who get hurt by these laws are almost always the people who did not know they applied to them. Hit the like button so this video reaches more people who need it. Subscribe because we cover Florida law in plain language every single week. Tenant rights, traffic laws, immigration updates, and everything in between. And drop a comment below. Tell us what county you are in, what questions you still have, or what situation you are dealing with. We read every comment and we turn your questions into future videos. That is how this channel works. See you in the next one.